A very good evening to you, ladies and gentlemen. I'm excited to welcome you to the BASL webinar organized by the Seminar Committee of the BASL for 2021-2022 on the topic Sports Law and Regulations. This is the 53rd webinar of the first webinar series hosted by the BASL, conducted on the Zoom platform. And for those of you who are unable to register on Zoom, hopefully you are joining us on the YouTube live stream on the BASL YouTube channel. Before we start, we would like to thank the Seminars Committee of the BASL. Firstly, the Chairman of the Seminars Committee, the Secretary of the BASL, Mr. Rajiv Amarasuriya, Convener of the Seminars Committee and Assistant Secretary of the BASL, Mr. Pasindu Silva, and the co-conveners, Mr. Pandula Vamniarachi, Mr. Oshan Uberatna, Ms. Anne Devendra, and Ms. Nikini Mapitigam. I would also like to take this opportunity to thank the President of the BASL, Mr. Salient Piris, President's Council, and the other members of the Management Committee of the BASL for all the support and guidance they have provided us. Today's topic is on sports law and regulations, and it gives me great pleasure to introduce the esteemed panel and moderator for today. The first panelist is Mr. Chandan Liana Patabandi, President's Council. Mr. Liana Patabandi is a proud Anandian. He was enrolled as an attorney at law in the year 1989 and has been in active practice as a counsel for nearly 29 years. He has been awarded a Master's in Law in International Trade Law by the University of Wales. Prior to establishing his own practice, Mr. Liana Patabandi has practiced as a junior in the chambers of late Mr. Chula de Silva, President's Counsel, Mr. K. Bala Patabandi, President's Counsel, Mr. S.A. Parthalingam, President's Counsel, Mr. Ranjan Mendes, and Mr. Ranjan Suwandaratna, President's Counsel. He was actively involved in the activities of the Bar Association of Sri Lanka and has been a member of the Bar Council nearly his entire career. He has participated as a resource person in many law conferences and addressed seminars and presented papers, sharing the wealth of experience and knowledge gained during his professional career. He was also the chairman of the Junior Bar Committee in the year 1999 and was instrumental in forming the Junior Bar Forum. Mr. Liana Patabandi specializes in civil and commercial law and has a considerable interest in aviation law as well. He has also represented an interested party at a Parliamentary Select Committee session. He has functioned as the chairman of the Dispute Resolution Panel appointed by the then Minister of Sports, Honorable C.B. Ratnayaka. He has been serving as the honorary legal advisor of the Sri Lankan Cricketers Association, which is affiliated to the Federation of International Cricketers Association. Our second panelist for the day is Mr. Sumathi Dharmavardhana, President's Counsel. Mr. Dharmavardhana is an old boy of D.S. Senanayak College, Colombo. He has joined the Attendance Department as a State Counsel in the year 1994 and now serves as an Additional Solicitor General with effect from 10th May 2019. He has read for his Masters of Law at the prestigious National University of Singapore. Mr. Dharmavardhana has been appointed as an adjudicator of the Asian International Arbitration Center in Kuala Lumpur, Malaysia, and is a certified sports arbitrator. The Shenzhen Court of International Arbitration in China has appointed Mr. Sumathi Dharmavardhana as a member of its panel of arbitrators from 21st February 2019. His Excellency the President of Sri Lanka has appointed Mr. Dharmavardhana as a President's Counsel in 25th June 2019. Mr. Dharmavardhana is also a supervisor of telecommunications law in information technology and sports law at the Attorney General's Department and contributed in drafting IT laws, telecommunication regulations, and the Prevention of Offences Relating to Sports Act. He is a member of the Appeal Board of Sri Lanka Anti-Doping Agency. In addition, he advises the Ministry of Sports with regard to legal matters, including drafting new sports legislation. Mr. Dharmavardhana has represented the government of Sri Lanka at the 29th session of the United Nations Commission on International Trade Law Working Group in Vienna and continues to advise the government of Sri Lanka with regard to ongoing UNCITRAL reforms pertaining to arbitration, adjudication, and investor-state dispute settlement. The final member of our panel is Mr. Panduka Kirthinanda, attorney at law. Mr. Kirthinanda was called to the bar in the year 1993. He has been in active practice in both criminal and civil law for the past 27 years. He was a legal consultant to Ministry of Sports during the period of 2010 to 2015 and was a legal consultant for the Ministry of Telecommunication, Foreign Employment and Sports Law during the period of 2018 to 2019. He has actively contributed in the implementation of the National Association of Sports Regulation number 1 of 2013, the National Sports Policy in 2012, Convention on Doping in Sports Act number 33 of 2013, and Prevention of Offences Relating to Sports Act number 25 of 2019. He has served as a member of the National Sports Council in during 2010 to 2015 period, and also during the period of 2018 to 2019. He's a former board member of the Sri Lanka Anti-Doping Agency and a former chairman of the Sugadadasa National Sports Complex Authority. He has represented the Ministry of Sports as a legal consultant for IOC, ICC, UNESCO, and has served as a member of inquiry on sports arbitration, both locally and internationally. And the moderator for the evening is Mr. Danyal Gunawardana, attorney at law. Mr. Gunawardana is a former industrial relations advisor of the Employees Federation of Ceylon and holds an advanced diploma in finance, management, and accounting from the National Institute of Business Management of Sri Lanka. Currently, he is reading for an MBA in Human Resource Management at the Open University of Sri Lanka. He is an EXCO member of the Sri Lanka Lawyers Cricket Club, the present vice captain of the Sri Lanka Lawyers Rugby team, and the chairman of the Bar Association Sports Committee for the year 2021-2022. Members joining this session by Zoom may send their questions through the Q&A chat box to reach the moderator. Without further ado, let me hand over the proceedings to the moderator. Over to you, Mr. Gunawardana.
Thank you very much, Tanuja, for the lovely introduction. And I warmly welcome the viewers for this 53rd webinar of the Bar Association of Sri Lanka. And let me initiate this discussion by inviting Mr. Panduka Kirthinanda to speak on the sports law number 25 of 1973. Sir, these days your name is coming up in media frequently, and we know that you have been appointed as a member to investigate and inquire into the recent incidents that took place during the Sri Lanka cricket team tour to England. And also, sir, you have been a long-standing consultant of the Ministry of Sports, and you have dealt with the sports law thoroughly. So also, with the appointment of the new Minister of Sports, we heard that that there was a discussion about the new Sports Act and the National Sports Policy. Sir, let me put to you whether the present sports law is comprehensive enough to cover the areas that need to be looked into the future. So also, I would like to request you to discuss about how can we bring the sports law in line with the great sporting nations such as New Zealand, Australia, and South Africa. So also, I would like you to discuss, sir, about independent sports arbitration, which is needed for us to take our sports to the next level. Sir, thank you. Over to you.
Thank you very much, Dania, for giving me this opportunity. And I'm very much humbled and honored to whatever I could give my statement today. Actually, before coming into sports law, I would like to give a briefing about the sports history of Sri Lanka. As we all know, in 1948 in London Olympics, Duncan White won the 400-meter hurdles silver medal. Thereafter, after about 60 odd years, Susantika Jayasinghe in 2000 won the silver medal for 200 meters. And also we have achieved in many events in Commonwealth Games, Asian Games, South Asian Games. And we can't forget in 1996, Sri Lankan cricket won the greatest cup, the World Cup in 1996. Before that, I would say that the sports law was initially implemented during Honorable K.B. Ratnayaka, then Minister of Parliamentary Affairs and Sports in 1970 to 77. I would like to start very briefly how Honorable V.A. Sugatadasa was the first sports minister from 1965 to 70. He was a sportsman and he was a footballer. He played for Sri Lanka football team and he became a politician. During his tenure, his secretary was one of the class 1 civil servant, Dr. H.S.R. Gunawardena was the first sports ministry secretary. Thereafter, Honorable K.B. Ratnayaka was elected during Sirimadi Bandaranaike's Prime Minister's time as the Minister of Parliamentary Affairs and Sports. Then he appointed a 3-member committee. Dr. H.S.R. Gunawardena, the then former cricket captain, Major General D.R. Hines, and T.B. Veerapitia. Later on, Honorable T.B. Veerapitia also became a minister during Jaya Jayawardena's time. The important thing is, those days there were no politics involved. They were purely wanted to support the sport, develop the sport, and to bring up to this level. It was a golden era. We had only limited facilities. We didn't have the international infrastructure facilities in sports. But in this report, they clearly mentioned that we need to bring a sports law. That was the beginning, and that was the time that in 1973, the sports law was implemented in Sri Lanka. For that, I think the British sports law and the Indian and many other countries' laws were influential to this sports law. The law was implemented in 1973, and thereafter, in 1974, under the sports law, the first sports regulation was implemented. That was the time that just before the first World Cup of Cricket World Cup in 1975. So, as per the regulations only, all the sports bodies were registered under the Ministry of Sports, including the cricket, football, rugby, hockey, and so on. there were about 55 sports was registered under the Ministry of Sports, and after the registration only, this law will implement for these sports bodies. So, actually speaking, especially in sports, we need to develop the sport, and also we need to control the sport. That is very important. Therefore, the regulations will come into force. The sports policy was implemented in 2012. In 2012, the sports policy had 46 areas, especially in those sports policy was implemented under Minister of Maindananda Alutgamage. I was also in the ministry at that time as a legal advisor and a sports law committee, and we implemented the national sports policy. Thereafter, in that policy, we have clearly mentioned that sports culture should be the tourism, and the sports culture could be developed in the country. How to develop, and what are the areas that we have to support, especially establishing the sports framework for sports development and management and infrastructure development areas, and also so on and so forth. If we go like that, we wanted to have the independent sports tribunals, especially in the world. There are sports dispute resolutions conducted in independent manner. So I strongly suggest that the Sports Dispute Resolution Act should be passed in Sri Lanka, because we have the anti-doping law, we have the anti-corruption law, and the sports dispute resolution should be the most important thing at the moment, because the flexibility, the time and the cost efficient mechanism should be there, and also it should help the parties in sports to resolve their disputes in independent and international. It has to be par with the international rules and regulations and laws, and also we should conduct the sports code of ethics. So therefore, we have to amend the sports law. At the moment, under the sports law, the final determination of the appeal is given to the Minister of Sports, which is, I would say that should be amended, Section 30, and so many other areas should be amended. But this sports law should be there without bringing a new sports act. I think strongly I believe this sports law could be amended according to the new system. And we should bring the Sports Dispute Resolution Act separately. There we have accountability, independence, and also we could go with the international rules and regulations. So my area is that. So what I want to say is the sports law has to be amended in Sri Lanka in so many areas. And also we have brought the new laws like anti-doping and anti-corruption law into force. We are very much happy that anti-doping law was implemented in Sri Lanka first time in Asia, and anti-corruption, I mean sports-related corruption law, where my dear friend Mr. Dharmawardhan is going to explain, was also implemented in 2019. So the Sri Lanka is very much ahead of most of the Asian countries. When you think of India, they couldn't bring the anti-corruption law. So we have implemented those things. The sport has to be free and fair, and also it has to be clean. So the most important thing is, if we can amend the sports law, the present sports law has certain check and balances, especially Auditor General has to do the auditing. A part has to be there, but there should be little amendments, because if the certain sports bodies are getting funded by their international parent bodies, if they send the funding, we could give it to a reputed audit firm and get it audited annually. But if the government or the treasury funding is provided for any sports bodies, has to be audited by the Auditor General. There are issues when it comes to this area, and especially Olympic Committee of Sri Lanka and many other sports bodies had COPE inquiries with regard to the annual audit reports. So I suppose that we have to resolve these matters, and also corruption. If there is corruption, we have a clear law to deal with. So that on that part, we are fully covered in Sri Lanka in sports. So what we can do is bring the Sports Dispute Resolution Act and to make it flexible, time and cost efficient, and also there should be a mechanism to help the sports parties who has to resolve their disputes. Otherwise, this goes to the district court or some goes to writ applications. So thereafter, it could go even to Supreme Court. There are certain matters pending in Supreme Court for months and years. So in sports, you cannot allow to go like this. In that, the sport will never develop. So therefore, if you bring that area as a new law to the country, I think we will have a better future as sports areas. So also, I would say that Sri Lanka is an island, and we have very much talented athletes. We have brought the infrastructure to a higher level. We have the capacity to find the best athletes and the players to implement the best sport nation in Asia. That's what the sports policy clearly says. And we have brought the new laws into force. And if we can amend the sports laws according to the international rules and regulations, and if we bring this Sports Dispute Resolution Act, I think that would be the best possible thing we could do for sports at the moment. I would like to take this opportunity to thank the Bar Association and also the moderator, Dania, and also Nikini, and also the secretary, Rajiv, and our two honorable speakers, Mr. Chandana Liyana Padabendi, President's Council, and Sumati Dharmawadana, President's Council, my colleague. And they have contributed immensely to the sports in recent time, especially Mr. Dharmawadana keenly supported and initiated the sports-related corruption law, and we are in the verge of doing the sports. Entire sports policy should be as per this 2012. So what we are trying to think is if we can implement these new areas to the sports law, I think that would be the best possible thing we could do. Thank you.
Thank you, sir. So what Mr. Panduka Kirtinanda is saying is that the present sports law is sufficient enough for us to move forward, and there is no requirement for a new sports act. But however,
there should be amendments to the present law.
Yes. Sir, may I pose this question to you for the in the interest of our viewers? So yes. Now, is this law sufficient for us to? Now, this law has been there for numerous years. Over 3 decades, we have been having this law, and also there have been piecemeal amendments coming in. Sir, but now if you look at countries like Australia, New Zealand, South Africa, when you look at their sports law, is our sports law on par with those developed sporting nations? Can we also achieve the same results that they have achieved in sports through better management of our facilities, and bringing in better regulation to enhance the performance, and also especially in the areas of selection and making sure that the talent pool is brought through the structures that are in place by the sports law.
Yeah, thank you. It is a very important question. So our sports law has been amended 3 times. One is in 1993, 1998, and 2005. That still we have to have the amendments. We have actually in 2019, we have drafted the amendments to this present law, sports law, Act number 25 of 1973. We have studied very carefully with the Attorney General's department. I have the proof copy with me, the AG's approval, and also the legal draftman has drafted the areas. What I want to say is, if you take out this present law, it's very difficult to bring it back. Similarly, same thing happened to India. India did the same mistake, and International Olympic Council, they opposed to this. Thereafter, there was a Supreme Court case came up. Finally, Supreme Court gave a ruling. I have the report with me. If I can read out the area. Supreme Court gave a ruling that there should be law of the country. There should be law of the country. And you have to, you cannot always take the international law and implement here. Because in United Kingdom, non-interventional approach to the sports law is there. They don't have a sports law. They have policies. So if someone violates the sports law, they will go into sports dispute resolution areas, and they sort out this matter. But in Sri Lanka, we are funding the Sri Lanka government is more than, other than the Sri Lanka cricket, football, rugby, and few other sports, 70% of the sports bodies are funded by ministry funds, the government funds, taxpayers' funds. So we have to regulate and see. There are a lot of misuse, corruption. So we have to regulate. If the government is funding, we should have the accountability. If the government is funding, we should know that they are using these funds for the betterment of sports, not for their pockets. So if you take in South African law is, they are controlling. The government is controlling the sport, and they are implementing all the infrastructure, development, and also rules and regulations as per the South African Sports Act. That's called the National Sports Act and Recreation Act of 1998. And if you take Pakistan, Sports Development and Control Ordinance, that was implemented in 1962. They have not touched into that. If you take Australian Sports Commission, that was implemented in 1989. They also have the controlling power. And in New Zealand, the Sports and Recreation Act number 2002 in 2002 they have implemented this. So what I want to say is, this present sports law could be properly do the changes. We have done the amendments according to the International Olympic Charter, ICC, International Cricket Council rules and regulations, as well as other international sports bodies code of ethics. But if you take out this, what will happen is, if we are going to give 100% freedom to the sports bodies and become non-interventional, do you think that, Danya, this will go on correct track? We will have a lot of problems. Then we can't take it back. If you release it, we can't take it. This sports law was implemented, carefully they drafted this after about 3 years studies. That is the reason why in 1980s, most of the legislation were amended, changed. but they didn't touch the sports law. They only did 3 amendments. Now, even if you take 1978 Constitution, whatever said and done, still we are using the same Constitution. There are 20 amendments. So why can't we do the changes, do the amendments as per the present international necessities and leave the sports law? But we must, in addition to this, we have to bring the Sports Dispute Resolution Act, and that allow that to be independent. No intervention, no interference with the government, no minister cannot involve with that. Independence and the international rules has to be implemented on that, and the code of ethics have to be accepted by all parties. So then the check and balance will be there. If someone takes a wrong decision, go on the wrong track, or have any illegal activities or misconduct or manipulation in sport or corruption in sport, the minister in charge of the sport should have the power to correct this and put them on the correct track. All these sports bodies are honorable, and also they are these members are being elected by their sports bodies. So election has to be conducted free and fairly. There should be proper rules and regulations. So all these could be handled if you do the amendments. But if you take out this act and try to bring a new act, International Olympic Charter, ICC, International Cricket Council, and many more international bodies will object to this. And they can't object because this is the previous law we had. When the ICC law was implemented, we allowed this law to be there. Do the changes, amendments, and have this Sports Dispute Resolution Act separately, and then we have a sports law is there, Dispute Resolution Act is there as per the international level. Then anti-corruption and anti-doping law is also there in our country. So that is sufficient enough to conduct and support the sport.
Thank you very much for your input. And let me invite the next speaker for the evening, Mr. Sumati Dharmawardhan, President's Counsel and the Additional Solicitor General of the Attorney General's Department. Sir, you have been an advisor to the Ministry of Sports over a long period of time. During your tenure, you have served in the numerous panels to amend the sports law of Sri Lanka. So also, so I believe the highlight of your career in relation to sports law is getting directly involved in the drafting of the Prevention of Offences Relating to Sports Act number 24 of 2019. Sir, for the interest of our viewers, this law is a very comprehensive law. When one looks at it, there are a lot of technical terms which needs clarification. Because, in instance, the law does not describe what is corruption, but it is wide enough to encompass the needs of the modern day sport, where sportsman integrity is very important. And also, we have experienced recently that especially the sports in international scenario is plagued with scandals of match fixing and acts of corruption, bribery, and there are various problems which needs to be addressed. As the sports law was not sufficient enough to cover these areas, this law was brought in. Sir, may I invite you to discuss the salient features of this act and to explain to our viewers how this law can move forward and whether this law is sufficient for us to meet the challenges which is faced especially in international sport?
Thank you, Danya. Good evening, ladies and gentlemen. I'm very pleased to associate myself with an eminent panel consisting of my dear learned friends, Mr. Chandana Liyanapatapanthi, President's Counsel, and Mr. Panduka Kirtinanda, Senior Attorney at Law, with whom I have associated for quite a long time from the time I joined the Law College. Danya, in order to answer to your question and having listened to what Mr. Panduka Kirtinanda explained on today, the 1973 Act, at that time, it's a masterpiece in my view, because as Mr. Kirtinanda may recollect, we had certain issues which the government of Sri Lanka faced when the government tried to administer and manage certain national sports associations. Somewhere in 2013 or 14, the International Olympic Committee went into the extent of banning Sri Lanka from the world arena. At that time, I was part of the delegation, which led by then Minister of Sports and my learned friend Mr. Kirtinanda who joined. We went to Geneva and had discussions with the International Olympic Committee. And after presenting the Sri Lanka side, there was a decision taken until we amend the sports law of 1973 to bring in regulations, especially with regard to the management and administration of the national sports associations. That authority has been given in terms of the 1973 Act from section 29 onwards. On 27th October 2016, a comprehensive regulation was promulgated giving details from the registration of a national sports association and then the duties of the National Sports Association, especially what should contain in the constitution of a National Sports Association, which is managed by volunteers in Sri Lanka. Keeping in line with the International Olympic Charter, we drafted this, and for last 5 to 6 years, the Sri Lanka's National Sports Associations are governed and managed through this regulation. That it was due to the Act having certain lacuna, because in 1973, the Parliament in its own wisdom never thought there will be issues in the sporting arena. Having said that, especially in section 2 of the regulations, contains what are the matters a National Sports Association constitution should have. In that, it has gone to the extent that the treasurer should come from the banking industry or from the financial industry, or at least a certified chartered accountant, or who had done at least one part of the CIMA exam. That is in order to maintain proper accounts, which has created a number of issues. Lack of transparency, lack of knowledge for them to follow the procurement procedures led into a number of corruption issues. Unless otherwise we address the issues in the National Sports Association level, we won't be able to have clean sports in Sri Lanka. That is why when it comes to the new Act, we have brought in even the members of the National Sports Associations can be inquired under the new Act for corruption. So having said that, I will take you all through the some of the slides. But before I move on, I must emphasize the 2016 regulations requires for the National Sports Associations to submit an audited statement before the next AGM. If not, the AGM is not valid, and failure to attend to the said requirement has led to a number of court cases being filed. So therefore, the people who are involved in the sports arena are day by day getting educated and some of the interested parties also keeping an eye on what the volunteers in national sports bodies are doing, whether they are acting in accordance with the regulations or not. So therefore, at the time we are bringing the new amendments to the sports law, we have to consider these matters and bring the necessary amendments. One more matter I must bring to the notice of the audience. At the time, the 13th Amendment to the Constitution of Sri Lanka was introduced, where the devolution of power was discussed. One of the aspects in the 13th Amendment is the administration of the national sports associations to be under the Minister of Sports of the central government, for a very pertinent and important reason, because the sports is can destroy the unitary state of Sri Lanka. There can be only one flag, one national flag, under whom participants can take part in international sporting arena. We saw our team in Tokyo Olympics marching under the lion flag. In order to maintain that, the framers of the 13th Amendment to the Constitution has specifically brought the All National Sports Association under the control of the minister. This is a one issue. When they wanted us to liberalize the regulations, we had to inform the International Olympic Committee. In no way we will take that matter out of the control of the minister. Having said that, I will now coming to the presentation with regard to the new Act of 2019. Let me take you all through the slides. Give me a minute. In fact, Danya, you mentioned that there are a lot of technical jargon in the match fixing law, because the match fixing is related to illegal betting. And therefore, first of all, I would like to enlighten, there are two identified categories of match fixing. What is available in the slide, I hope you can see it, Danya. The betting related match fixing and the sporting motivated method of match fixing. When we say the sporting method of match fixing, that is where the clubs will wanted to come up in a tournament, and therefore they decided to give a walkover to the other side or the other group. But when it comes to the betting related match fixing, they are persons who are connected to the illegal betting, and in order to get a financial advantage, they get a person or persons who are connected to sport. So in the Act, I will take you all through. We have created two distinct categories. One, the person connected to sport. That means a sports person, either a curator, a physician, coach, the cricket, or rather the sports administrators, and so on, which in the Act there is a definition given. As I told, the sporting motivated method of match fixing is less involved of the betting industry and maybe due to a financial benefit to the club. When it comes to the impact of match fixing, you all may have seen the sportsman losing career, and it has destroyed the social fabric. And due to that, even the sponsors from the commercial world will not come forward to sponsor sporting events. There are two known cases which I will be discussing in today's webinar. One is the imposition of a life ban of former Indian Test captain Mohammad Azharuddin, and conviction of Pakistan star cricketer Nazir Jamshed by UK Crown Court. Impact of match fixing is not limited to a nation or a country. It is linked to gaming syndicates, interconnected to a number of operators in different jurisdictions. It has gone to such a level, if you check all the international media, they report about the global match fixing rackets, including cricket, which are under attack from organized crime syndicates. The anti-corruption code of sports governing bodies are all available, not even in the National Sports Associations or Sri Lanka Cricket, but it's available in the International Cricket Council, the anti-corruption code, as well as in the International Olympic Committee, the code on the prevention of manipulation of competitions. However, these codes are limited to inquire into their sports people because it's based on a contractual arrangement. They cannot go out of the ring and check who are involved from the people who are outside the sporting arena. I will directly go into the International Olympic Committee Anti-Corruption Code. In December 2015, the Executive Board approved the Olympic Movement Code on the prevention of the manipulation of competitions, and they requested all member states, international federations to implement the same. If you look at the Olympic Charter, Article 25 and Article 43 deals directly with this requirement, which I discussed with you all. In addition to that, you are required to comply with the World Anti-Doping Code. There can be individuals who will purposely malperform or superperform by taking prohibited substance. I'm sure this will be dealt by my learned friend, Mr. Chandan Liyanapatapalli, President's Counsel. Therefore, I will not delve into this. The illegal betting was really destroying the sporting arena, and due to that, the International Olympic Committee set up the Integrity Betting Intelligence System in 2013. And the IBIS collects and distributes information and intelligence related to sports betting for use by all stakeholders of the Olympic movement. When an inquiry crops up, there is a standard defense what we have seen in Sri Lanka, and they have taken up even in the Court of Appeal. What the sportsmen they say is there was no proper inquiry. Allegations made against the sportsmen are unreasonable. Inquiry was conducted by the officials of the National Sports Association, and they were biased. Due to these reasons and due to the requirement of the international organizations, especially the International Cricket Council, who had constant discussions with the Ministry of Sports, the government of Sri Lanka decided to enact the Prevention of Offences Relating to Sports Act 2019. The first draft was prepared somewhere in 2012-2013, and my learned friend Mr. Kirtinanda also played a pivotal role in the early stages. Thereafter, the matter was referred to the Attorney General's Department. I was honored to get involved in this exercise in order to clean up the Sri Lanka sporting arena. At that time, we decided to look at the legal position in the United Kingdom. There were two important cases in UK. First one was the match fixing at the Lords in 2010, where the reporters of the News of the World in UK exposed 3 Pakistan cricketers for fixing test cricket matches at the Lords, which was widely known as Pakistan's spot fixing scandal at Lords. International Cricket Council commenced an inquiry chaired by Mr. Michael Beloff QC. They found them guilty. Thereafter, the Crown prosecutors charged them, and then the Southwark Crown Court found them guilty. However, Majid and Westfield versus Regina case is reported due to their appeal in the Court of Appeal. Matter was considered by the Lord Chief Justice of England and Wales, Justice Openshaw, and they upheld that the decision of the Crown Court based on the Prevention of Corruption Act of 1906. And I would like to quote from the next slide. You can see Section 1 of the Prevention of Corruption Act 1906. It says, if any agent corruptly accepts or obtains or agrees to accept or attempts to obtain for any person, for himself or for any other person, any gift or consideration as an inducement or reward for doing or forbearing to do, or for having done or forborne to do any act relation to his principal's affairs or businesses, or for showing or forbearing to show favor or disfavor to any person in relation to his principal's affairs or businesses, he shall be guilty. This is the section which the 3 Pakistan cricketers were charged, and the Court of Appeal of UK upheld the same in Majid versus Westfield. In these slides, I have quoted some of the other parts from the judgment, but I will not go into it due to time constraints. What happened thereafter? Thereafter, again, somewhere in 2017 or 2018, the National Crime Agency of United Kingdom started following and conducted a covert operation with regard to another match fixing scandal involving the T20 cricket tournament to be held in Dubai. They followed Nasir Jamshed and few others, and then after a covert investigation by the UK National Crime Agency, they decided to charge them. However, there was no specific law in UK, and the matter was outside the jurisdiction of the United Kingdom. Therefore, the Crown prosecutors decided to make use of the UK Bribery Act 2010. I had the privilege to discuss this case as well as our draft law with the Crown prosecutors at the time this case was going on. And it was very helpful to finalize our draft, because this type of organized crimes are crimes beyond borders. So we need to have extraterritorial jurisdiction, which we have incorporated into our act. And in terms of the UK Bribery Act, if any person who is involved in UK but conducts do an offense outside UK, they can be charged. It is very important to note what Justice Mansell decided in the Nasir Jamshed case. In this case, Judge Mansell stated that it came to light that match fixing was taking place in conjunction with the gambling syndicates in Indian subcontinent, and special reference was made by him. We are next to India. I don't have to tell you all. The media has highlighted number of allegations. We need to inquire into it. And let's look at what happened in India. There is a very interesting movie by Sony Pictures called Azar. And when you do a search on what happened on Mohammed Azharuddin's case and this movie, you can get a picture of how match fixing is taking place. The Indian Central Bureau of Investigation conducted an investigation in year 2000 due to a statement made by the South African cricket team and Hansi Cronje about match fixing allegations came to light against Mohammed Azharuddin. Based on the Central Bureau of Investigation report, the Board of Control for Cricket in India decided to impose a life ban on Azharuddin. He decided to challenge the decision of the BCCI in the Hyderabad civil courts. The civil courts dismissed Azhar's case on August 2003. Thereafter, he appealed to the High Court of Andhra Pradesh. Justice Mohunta and Sri Justice Krishna Mohan Reddy quashed the life ban imposed by the BCCI, and they held that the ban on the cricketer was illegal and unsustainable. As my learned friend Mr. Kirtinanda pointed out, there is no specific law to control match fixing in India. However, even though the Central Bureau of Investigation conducted a comprehensive investigation, the Indian prosecutors did not file criminal charges against Azhar. And due to that, Azharuddin's life ban was lifted. And now let's see what we did in Sri Lanka. Due to the absence of a domestic law, we had to bring in a new law. And in 2019, the parliament enacted the match fixing law in Sri Lanka, which is known as the Prevention of Offences Relating to Sports Act number 24 of 2019. In this, we have categorized two groups of people. One is the persons within the sporting arena and the people who are outside the sporting arena, which is in the green color. In this slide, you can see. Let's look at the salient features of the Prevention of Offences Relating to Sports Act number 24 of 2019. The section 2 and 3 deals with the authority vested with the Ministry of Sports to strengthen national and international cooperation. And the part 2 of the Act deals with the offences of match fixing, corruption, illegal manipulation, and illegal betting. In section 4.1, it says any person or any person connected to a sport who directly or indirectly, alone or in conjunction with another or others, gets involved in any arrangement on an irregular alteration of the cause of the result. I wish to emphasize, involved in any arrangement or an irregular alteration of the cause of the result of any sport or sporting event for money or any other reward or benefit, including any arrangement where then it goes from A onwards. And I have highlighted in 4.1a Roman 2, it says acts in a manner that ensures the occurrence of any improper performance, act or omission, and outcome which is the subject of an illegal bet relating to a sport or any sporting event. All these improper performance, act, omission, or outcome has to be linked to a illegal bet. How do we find out whether it was related to illegal bet or not? That is why a special investigation unit had been set up to inquire into these allegations. I will be dealing it in a shortly. Let's look at section 4. As I told you all earlier also, there are two categories of persons: any person or any person connected to a sport, which covers both categories of possible offenders who falls within the sporting arena and outside the arena, because gambling syndicates are people who are outside the sporting arena. So there has to be an interconnection between these two groups. Section 5 and 6 deals with the offense of corruption in sports and offense of illegal manipulation in sports. Offense of corruption in sports is set out in section 5. Any person or any person connected to a sport who solicits, accepts, agrees, or accepts or offers money or any other reward or benefit, B, controls any other person or thing for such person's own advantage or to the advantage of another dishonestly or fraudulently. C, solicits, entices, persuades, induces, or instructs any person directly or indirectly to perform or refrain from performing an act. The improper performance, which Danya question, is in section 6. It says any person or any person connected to a sport who influences improperly, unfairly, or dishonestly the result, progress, conduct, or any other aspects of any sport or sporting event commits the offense of illegal manipulation in sports. Having said that, let's see what will be the fine. Betting and gaming is described in section 4, and I will leave it and directly go into the offense, the punishment. The punishment is stated as follows: any person who commits an offense specified in section 4, 5, 6, 7, or 8 shall on conviction be liable to a fine not exceeding rupees 100 million or to imprisonment for a period not exceeding 10 years. As I told you all earlier, there's a special investigation unit appointed by the minister, but who has to report to the Honorable Attorney General with regard to their investigations. They have the right, no sooner they come to know that there is a prima facie offense had taken place, and to look for the ill-gotten wealth. That is through calling for a declaration of assets. All the sports people and all the persons who are come under the purview of the Prevention of Offences Relating to Sports Act number 24 of 2019, the Special Investigation Unit has the authority to request them to declare assets of any person, spouse, and child of such person, and it is limited to immovable and movable properties. And in addition to that, SIU has the power to obtain all bank details from all banks in Sri Lanka, as well as they can cooperate with the international organizations and check for the foreign bank details. The declaration of assets prior to this was only limited to the public servants. The Bribery Commission Act has provision where all public servants has to submit an annual declaration. In addition to that, if there's an asset inquiry, they will be called upon to submit a fresh asset declaration. Similar provisions have been incorporated into this act, having understood the degree of corruption taking place in Sri Lanka. Therefore, the Special Investigation Unit can direct all persons to submit their asset declarations for them to ascertain whether any person has got any ill-gotten wealth. The authors of the act have taken adequate measures to empower the Special Investigation Unit to conduct effective investigations. I'm sure everybody will agree, without this salient feature, the outcome of a proper investigation will be very much doubtful. Offences under this act shall be investigated under the provisions of the Code of Criminal Procedure Act. The officers of the SIU has to ensure that they maintain utmost secrecy during the investigations, and they should immediately seek the advice of the Attorney General about the next step they have to take. Even though there are wide powers vested with the Special Investigation Unit, in order to maintain balance, they have to submit cogent evidence of a suspected offense to the Honorable Attorney General, and through the Attorney General's advice, they had to take action. Section 21 of the Act empowers the Minister to appoint an independent and impartial Special Investigation Unit. And if there is any conflict of interest, the members of the SIU, headed by an officer above the rank of an Assistant Superintendent of Police, should bring it to the notice of the Minister, and there's a time period for them to serve in the SIU. Making false allegation. This is also another important factor which this act has considered. If somebody makes an allegation and it happens to be false, the SIU can conduct an independent investigation pertaining to the false allegation, and it is a punishable offense under section 16 of the Act. As I told you all, institution of criminal proceedings is entrusted to the Attorney General, keeping in line with the best practices adopted in Sri Lanka. I discussed the role of the Attorney General. Honorable Attorney General will take steps as provided in the Criminal Procedure Code, as well as we can make use of the provisions set out in the Prevention of Money Laundering Act with regard to the proceeds of unlawful wealth. Having said that, with my limited time period, I think I have come to the end of my presentation, but I look to answer any issues or questions during the Q&A sessions. I think, as we discussed in the beginning, Sri Lanka is one of the first in the Asia to bring a new legal regime to curb match fixing, and I'm sure with the efforts of the Special Investigation Unit, who can conduct a very comprehensive investigation pertaining to allegations and submit a report with cogent evidence to the Honorable Attorney General, we will be able to put an end or to limit match fixing in Sri Lanka. Danya, over to you. I think from the limited time you all allocated to me, I trust I was able to bring a proper understanding about this new law. But if I try to go into other sections, I think I will be taking time from my learned friend, Mr. Chandana Liyanapatabendi, President's Counsel. Over to you, Danya.
Thank you very much, sir. That was a very insightful discussion on the new act which has been passed in 2019 to deal with corruption in sports. Let me now go to our next speaker, President's Counsel, Mr. Chandana Liyanapatabendi. Sir, you have been involved with the sports management of Sri Lanka well over 3 decades. Sir, during this time period, you have appeared for many national sports association, and you are the man to go to for any dispute regarding sports litigation. Sir, in your area of expertise, you have served as a panel member of the anti-doping agency in Sri Lanka, and also you have thoroughly studied this area of anti-doping, which is very, very important. So may I quote from one of the articles by Richard H. McLaren. It says, "The very essence of sport is competition. Through the competitive spirit, athletes play against one another to determine who is best. Fundamental to each athlete's competitive spirit is the concept of an equal playing field, which is enshrined in the importance of honor and mutual respect in sports." So in this backdrop, let me invite you to discuss about the Convention Against Anti-Doping in Sport Act number 33 of 2013. Sir, the act is very wide, but in its operation, we might face practical impediments. For the interest of our viewers, may I invite you to discuss the salient features of this law and how this law will bring about the relevant objectives of the framers of this law. Thank you. So over to you.
Yeah, thank you, Mr. Danigunawardena, for getting me involved with another 2 eminent members Mr. Sumati Dharmawardana and Panduka Kirtinanda. Sumati Dharmawardana President's Council and Mr. Panduka Kirtinanda, whom I have been known as friends for a long time. And they have had the advantage of getting involved in from the Attorney General Department level or the Ministry level in formulating policy and drafting. So I think because of that, their presentations were very, very useful for me as well. Because I don't have a ready-made presentation, so that because I'm at the moment joining this session while I'm on holiday, but I think in formulating my own slides, I think I have got a lot of notes, and I will have to listen to this again, and I can develop my presentation along with this. Now, thank you very much for the Bar Association of Sri Lanka for getting us involved in this presentation, especially its president, its secretary, and the seminars committee, and as well as the Tanuja Migahavatta for giving me the introduction. And without it was his mistake. I think I'm now command about 31 years in practice, going into the 32. The first of all, you wanted me to speak about the salient features of anti-doping law. May I take a little bit away, because slightly I will come back. Now, when other two speakers addressed, we have learned that we have four statutory things here in Sri Lanka. That is the sports law, and the regulations. That is one. Because you can take regulations separately as well, as because it is very, very wide in application. That is sports law and the regulation. Number two, the anti-corruption laws relating to, that is where Mr. Sumati Dharmawardana's presentation, Act number 24, 2019. And there's another act, that is the fourth act, fourth statutory regulation is the anti-doping law. That is third three of 1913. And while listening to Mr. Sumati Dharmawardana, President's Council, he has mentioned the importance of availing the provisions of Money Laundering Act as well. So that is another aspect of sports law. Then other than that, we have another body of sports law outside these framework, which is coming under through the case laws and textbooks. That is where, like most of in the elite level sports deals with there is a commercial aspect of it. Players will have to have a contract with their governing body or with their sports club. So that is another area that comes mostly under the law of contract. And at the same time, the sports bodies, governing bodies, will have a different relationship with their international body. And the international body will have, that is also merely under because there is you are considered as a member looking into in your particular state, this particular game of sport. Then the recognition for that association of a local body is you get that recognition from the sports law. There are the sports law, sports ministry declares, and this particular, otherwise there are several clubs who are dealing with cricket or anything, but it is only one association is considered as a governing body for the game of cricket or like any other. So that is Sri Lanka Cricket Board, which is an unincorporated body. Therefore, it has a constitution. Other associations who are playing the tournaments are having they are connected through the constitution, and when they're paying tournament under the tournament rule. But that governing body coming into play with as a national governing body because of the sports law. So then that is again regulation. But then there are other aspects of it, like regulation of commercial activities like ambush marketing, where where you can't go to a particular place when the sponsor, because there are sponsorship laws. Sponsors have come into come into play with the governing body or the tournament, with relation to particular tournament. So then those laws, so that with that, and then at the same time, there is, if you go to ILO, World Labour Organization website, there is another new body of called the sports working place, rules related to sports working place, whether it's a contract, whether it's an independent contractor or an employee. And in that case, because their time is very limited, because it's in your youth age, you only pay the competitive sports and that elite level and the professional level. So all these, there are other body of law other than these 4 or 5 statutory regulation. There is this other body of law coming under the general law. It is not only the law of contract. There are laws relating to drafting of constitutions of various sports bodies, all that come into play. So I'm not just, I just to share with the viewers a particular book. This is kind of a Bible for me in dealing with this issue, sports law. It's a Cavendish publication. There are so many books that you can go into, and then because that is having an understanding of those areas are important when you are dealing as a practitioner. And then coming back to that, then I have already mentioned about the sports law, regulations, anti-corruption law, anti-doping law, and then this, and then the with the help of Mr. Sumati Dharma of the President's Council, we have learned that the relevancy of money laundering, and I have shown the other areas that is not coming under the statute. Now, when we talk about the statute, Mr. Sumati Dharma then specifically dealt with one area, and the other area by Mr. Pandukirthananda about the regulations. But the topic given to me is mainly on the anti-doping. Now, and also Danya with eloquently has referred to me a particular passage. Yes, Danya, we all know that we the apex body of sport is the International Olympic Committee. So that unlike those days, any lawyer or anybody involved with the governing of sports, or as a sportsman or as a parent of a sportsman who is with a promising nature, can easily go into that first source, that is the International Olympic Committee website, easily, because you don't have to now go to a bookstore. Because then in 1999 there had been a meeting that's called Louisiana Declaration. That is where the World Anti-Doping Code was first promulgated. Then it was discussed that, I will quote from that passage, the International Olympic Committee wishes to reiterate its total commitment to the fight against doping with the aim of protecting athletes' health and preserving fair play in sport. Any declaration we go against these principles are both wrong and misplaced. So that is their declaration. So that shows that their main thing is about young sportsman's health. We call it the sporting athlete. Any individual or a team player involving any sport is generally considered as a sporting athlete. And that is first primary concern is about their health. Number two is about, because he's trying to get by taking some substance, some undue advantage over the others and over the sport. So that when they considered, because there were this incident like Ben Johnson's incident, we all know that how it came to be, and thereafter we all know that one of our athletes, after declaring as the third winner, but she was thereafter given sometime later. But that time the glory of getting that medal at the right place was lost to her. So therefore, the Olympic, with the connivance of with the help of the National Olympic Committee, a United Nations body, that is, I think I don't know about that historical thing as to how how the UNESCO came in, that is United Nations Educational, Scientific and Cultural Organization had promulgated this convention for the prevention of doping in sport. So Sri Lanka, that was in 2002, 2005 in Paris. That is the general convention. That is, anybody can, after going through the Olympic Committee website, they can easily get into this convention. So convention is there, and thereafter, then Sri Lanka had ratified this in 2011. And then within 2 years thereafter, to act and to give effect to the provisions and to take on the responsibilities given under the act, Sri Lankan government in 2013 passed this act called Convention Against Doping in Sports Act number 33 of 2013. Now, loveliest feature is it straight away give reference to the convention. So that is the prime law. First, the International Olympic Committee's laws relating to doping. Number 2 is the convention. Number 3 for Sri Lankan athletics, Sri Lankan sports arena, it is this Act 33 of 2019. Now it's very important is to whom it applies, because as those who are involved in the sports arena and others like us lawyers will have to know when we advise or when act or against somebody to whom it applies. So section 2 deals specifically with that area. It gives 5 categories of people. It is not only the member of any sports team or an individual sportsman. It is any person who are members of any association or national association of sports established in terms of sports law. That is very important. And then any person affiliated member, club, team, association or league of any national association. So then broad spectrum of people are getting involved. Then any person who are participating in any sports activity, and then every person connected with the training of an athlete, as a physio, maybe as a main coach, all are involved at any level, including any member of his entourage. Even the manager is covered. We'll see how the application or how they are getting it, and then how they are thereafter getting tested. Every participant, including a minor, because we know that for the minors different laws are applicable, but here this specifically says including minor at any sport event being held in Sri Lanka or abroad. So, but however, before getting into the offences side of it, there is a lovely salient feature in this convention and the law is it gives, before testing or doing anything, it gives a particular athlete or his coach after interviewing him or his parent to know that there is something called Section 5 application. They can make an application in writing to the anti-doping agency in Sri Lanka, which is established under the very same act, for asking for an exemption to him because he or she is using a particular substance for therapeutic use. So that is the first thing. Before coming into the anti-doping testing, and he is given a chance to come out and say, "I'm taking this," but it can't be a banned substance. But there are other substances who are not drugs, not banned, but sometimes when they are tested, because they are in Sri Lanka, you get this Ayurvedic treatment, where even that can be considered later on as performance enhancement drug or a use or therapy. So then he can go and make that application. Then anti-doping agency has to refer that to a particular committee called Therapeutic Use Exemption Committee. Then they would consider that. They would consider that, and they can either permit with conditions or they can even prohibit it. And then there is another chance that is not coming under the disciplinary control, and when it goes, because that's a decision of a committee established under the anti-doping committee agency, that goes straight to the appeal board. I think Mr. Sumati Dharmadana is also either the chairman or a member of one such appeal board. Am I correct? Yes. So, and then being dissatisfied with that, that is, first you can make an application, then it can be considered, it will be referred to by the doping agency to the Therapeutic Use Exemption Committee, and then they send it to the whoever the party. If that athlete is dissatisfied with your ban, he can go and make an application to the appeal committee, and that appeal board decisions is also can be appealed against to the Geneva-based International Court of Sport, arbitration for sport. So that is the mechanism. Thank you, Sumati. I think you were trying to help me. Am I correct to say that you were also the chairman of one of the appeal boards?
Yes,
Yeah.
that's correct, Chandana. And in addition to that, it is, as you correctly pointed out, it is the Court of Arbitration for Sports, the apex body, and they have set up 2 ad hoc courts in the Tokyo Olympic Games as of now.
Yeah.
Thank you.
Yeah, thank you. In fact, and thank you, Ms. Damadana. In fact, I have received, you can see, this is also not magic. Anybody can get into the website and ask for these decisions, because they send by email the decisions. And in fact, I have received the decision of that ad hoc committee. That is, it is stationed in Geneva, but they have, because Olympic is happening elsewhere, to give decision in appeals in that arbitration panel have already set up an ad hoc body, and they have given several rulings by now. They have, in fact, I have received one such saying that, because it's all, I have contributed this email list. Yes, they have ruled out one tennis, some two athletes asking for some while challenging that, they have already given the ruling. So see the beauty of that legal mechanism. Now, having said that, let me now go to the that means that procedure is there for an athlete to come before the doping agency and tell them, see, I am using this particular substance, give me an exemption. Now, here, offences are given in section 3. It's no point me repeating that, but let me just touch it upon. Any person who induces, applies and administers any prohibited substance or use of any, applies any prohibited method are committing an offense. That includes even if there is an animal involved in the sport, like horse racing, if they have used that in that particular animal, that is also prohibited. So section 3 deals with that particular aspect of it. But, and then, and another thing, whoever who is trafficking that particular substance is also committing an offense, whether it happens in Sri Lanka or in a sporting event involving Sri Lankan teams in abroad. Then, even not only the mere commission of the offense, even the attempting or aiding and abetting or conspiring to do that is also covered under that. Therefore, you know that under the particular new laws, now your telephone recording can be taken, video footages can be obtained. So easily, if there is a after the testing possible, any person who is involved would be declared under this as a person who has committed this offense. But who is conducting this prosecution? It is unlike the Bribery Act. Here, the agent, because it says the prosecutions they are in the provincial high court established under the 13th Amendment. So that prosecution has to be done by the Honorable Attorney General's Department, and investigations with the help of the anti-doping agency. Further, it is not just taking the body of the athlete. Those who are others who are involved, who are administered that on him, and those who are others trafficking that, taking that, transporting that, will have to be found out, because only anti-doping agency can only find out that only in the body of an athlete after a testing. So that there is a criminal justice system of the island will have to be involved. Right? So that then there is this World Anti-Doping Agency, WADA, has published latest one in 2019, that is called 2021 Prohibited Substance List. It gives I will not be able to understand without the help of a medical personnel, but those who are involved in the sports training in the mature level, and the others who are in the particular field will know that these are really dangerous, because it will enhance that particular athlete's performance in that particular event. But at the same time, the Anti-Doping Agency of Sri Lanka is also conducting various research to find out, because in Sri Lanka there are other substances, like, even I'm not saying like there are Ayurvedic treatment can be taken as performance enhancement usage, so that they are testing and they are seeing whether they can develop a local kind of a list, and then and see whether these are also includes in this performance, and then they can adequately report it to the world body and do something, so that the offense, if proven guilty, will give particular 1 second, I just made a small note, because it's a high court offense. 500,000 is the minimum level, minimum punishment, minimum levy that can be levied, and the maximum is 1 million. So in between there is a prison term, plus he can also be banned for a particular from particular sport, from either participating in any level, so that this makes it very clear for us to understand that this now, first, it gives the athlete the power to ask for an exemption, or when he is tested before and at the sporting event, he has to explain. For the defenses would be, because when I read the world that is CASA, that is Court of Arbitration for Sports ruling, they have not only think of common defenses, they have considered those common displays, like from testing to sample taking, to keeping the sample testing, to transportation up to the lab, and whether the lab is accredited or things like that. From there, whether his appeal was considered at the lower level, at this is at the lower level, that is anti-doping body or his athletic body. So all that is they consider the defenses. One second. No, because if you read those judgments or the orders, that would say the punishments that are given. Sometimes the time taken to make that appeal and whether he has already suffered particular banning, whether he has lost certain income has also been considered. So after all, after the Sri Lankan anti-doping ruling, that ruling can be because that is disciplinary committee is in that is where I'm serving as a member. I have not got fortunately I have not got a chance to hear anything yet, but I heard there are certain things are on the way. So that anti-doping body agency has this for the exemption used for a particular committee. There is there is a disciplinary committee where these cases would be heard and see whether, because then it comes with the norm that these substances were found in his body. So then what punishment would be cast upon him? And that is, after that can be appealed against to the appeal board set up by anti-doping body, and which again can be appealed to the international apex body. So why it is so introduced is the world has seen, because in the in the sports arena, parents and the society, we all like to see our heroes. We find our heroes among the sportsmen as well. We have seen them as role models. But then if they are taking part and winning by taking certain performance enhancement things, knowingly or unknowingly, that is not correct. That is not good sport. Therefore, they have developed that in that statement at the 1999 Louisiana Convention. It says it is not quite correct because you are going to get an undue advantage over the others, undue advantage in the sport as well. So having said that, I think I have just touched upon that as a time now. May I be permitted just to mention about the litigation area? Sports law gives the national sport recognition for certain bodies as governing bodies as sports for the particular sport. Then they have the constitution and they have the tournaments and they have their various clubs established around that. But when the tournaments happen or when elections are coming in, the electoral list, whether the electoral list of that particular club or a particular governing body consists of the eligible members, because the eligible will be considered on the participation, not only on participation of tournaments or paying the membership and having submitted proper lists. So like that. So then they consider, then that is one of the areas where lawyers will have to consider whether this list of whether this particular list of electors are proper. Then at the same time, when election happens, there are objections taken to various people. Then the sports law envisages that you have to appoint an election committee to conduct that. Independent persons are bringing in. But sometimes these objections are not entertained. Then you have to go to courts, because you have to go to courts to prevent that, or that is for the district court, because that is under the private law arena. Then if it is if it happens during a time of a interim body, that is, there is something called interim measures where the sports minister can make interim measures and suspend the operation of a particular sports body and get an interim committee. In that time, if that happens, then you have to go to the Court of Appeal under the public law remedy, under the social remedy, because that appeal had not been considered. And there is this appeal board. I think Mr. Mr. Panduka Kirtinanda would tell us again about this appeal boards procedure, because appeal boards again consists of another eminent member of our profession, that is, or from the profession of judge. And then sometimes that has to be communicated properly to the Honorable Minister so that he can take a decision with regard to the election, or he can give a direction to the election committee saying that this particular decision had been received by me with regard to this election. And at the same time, tournaments, when it comes to the tournaments, tournament rules are the governing rules for that particular tournament. But still, if the tournament committee does not take that matter seriously, district court has the jurisdiction to look into these matters. Thank you very much for the opportunity given, and I'm prepared to answer few questions within the given time. Sorry if I had taken a little more time, but I think I have done the justice for the 3 areas I was asked to speak. Thank you.
Thank you very much, sir, for your insightful address on the topic. This question is directed to President's Counsel, Mr. Sumati Dharmawardana. Sir, now you discussed about the prevention of offences relating to Sports Act, and especially, sir, if you look at section 7 of the Act, it says it discusses about illegal betting. When you say illegal betting, sir, it denotes that legal betting is permitted within the corners of the Act. Can you explain it to the viewers? Because when you look at sport, it's a multi-million dollar industry. And can you explain what is meant by illegal betting?
Dania, thank you for raising this question. When we drafted this act, we were not even considering the situation in Sri Lanka, because most of the high-profile matches, whether it's cricket, rugby, or football, it involves international tournaments. In most of the countries, betting is legal. And even in Sri Lanka, even though there is no horse racing for betting is permitted inside Sri Lanka, but based on the foreign racing, they do betting here. The illegal betting is where the people get involved by obtaining inside information, and then they put that as a marketing tool to go on the betting. For example, when the Sri Lankan team is playing, you announce that within the first 5 overs, they will not get runs more than 20. And you get the both players to go very slow. If you look at one of the allegations against one of the top cricketers in India, was the betting operators say, we only want you to do this. Don't bet, go slow. So that type of issues are there. That is why we have enacted this particular provision. I trust I answered your question.
Thank you, sir. My next question is to President's Counsel, Mr. Chandra Lena Patamandi. Sir, you discussed about litigation in the National Sports Associations of Sri Lanka. So how can we prevent this needless litigation? Because the objective of the sports law is not achieved if the National Sports Associations are needlessly and unnecessarily entangled in litigation. The sport will suffer.
Yes, I think I will directly answer that by saying this. It is to be by adhering to the rules that are there in the sports governing body's constitution, because that constitution gives a particular level. If it comes for elections, under who are the people who are eligible to contest. The sports law says who are the people who are not eligible to contest. Like if you have been serving in a committee which had been suspended and where the interim committee had to be appointed, in that case, at the next election, you can't contest. If that provision is there, so that the election committee appointed by the particular sports governing body will have to first of all make sure that the membership register of the people who are eligible to vote or the associations or whatever is closed, and then only you can see whether that electoral list of the maybe associations, affiliated associations, whether they are properly have sent the required number of documents or information to the. So that having said that, then election committee will have to be very fair as expected by the law and the norms. That's what you are there to, because you are coming as an independent body of persons called election committee. You sometimes if the normal time under the normal sports under the sports law and the particular constitution of that, and otherwise if it is the interim committee, there is this minister appoints through the sports development director of sports development. So you have to act as a normal fair manner and applying the rules of sports law and the regulation and the rules of the particular governing body. And to prevent thereafter, there is another thing called appeal body. Now, I was appointed once during the time of a particular minister, that name was mentioned. What I did was I allowed those parties, there were not elections, I'm sorry about that's about selection, like whether you are entitled to go for this team, whether you are eligible to go in particular part tournament, because others have complained saying that, my son was not involved, is not selected, like that. There are a lot of, about 6 of them, I allowed both of them, all of them to first come before our committee in front of others to tell their story, and then we have given them a fair hearing. Once we give the fair hearing, they know that they are included. Then we have stopped even the district court litigations. Next day, litigation is settled under the rules we have, because we have promulgated. We have allowed them to understand that their grievance is either proper or just it is not proper, because we have made them to understand it a proper inquiry, which is recorded, and the inquiry proceedings are given at the same meeting. But there is this in the ministry, there's a proper thing where appointed by the honorable minister. There are certain prominent members of our profession is also in that appeal boards. If they consider this as urgent and given the ruling proper, I think we can prevent this district court. But I said lawyers will be very angry with me when we are saying that we should not go to, we should prevent always the litigation. But I always say adhering to the law is the proper method in doing so. Because otherwise, sorry to say this, always an injunction is involved, whether it's an election or about a team selection. If there is an injunction taken, it goes into 6, because no point of having elections if the elections are going to be stopped. Thank you.
So this question is for Senior Attorney at Law, Mr. Panduka Kirtinanda. Sir, you were of the view that the sports law is quite sufficient and to address the concerns in our sport in Sri Lanka.
Yes.
But at the same time, you were of the view that there should be amendments. And you discussed about sports arbitration. So there are a lot of young lawyers who are joining us today who are aspiring to study this subject of sports law. So can you, for their interest, what are the opportunities that can be created and the areas of practice that could be focused for young aspiring attorneys who wish to study sports law and engage in the practice of sports law, especially in bringing down independent sports arbitration to Sri Lanka?
Yes, Dania, thank you very much for asking that question. Dania is a very valuable question. Danya, in our law, sports law, section 30 talks about the appeal. Act number 25 of 1973. We have suggested that section should be repealed, and that power should be given to a appeal committee, independent appeal committee. The section, and also by bringing the Sports Dispute Resolution Act, separate act, there we could set up the like the tribunals. We can set up the tribunal. The lawyers, representatives could be represented, and within a short time frame, you have to resolve this. For example, if I have given a wrong decision, I go to courts, I take a writ. The entire sports body election will get held up. Similarly, same thing happened. Mr. Dharmavardhana knows about it. If I don't get the nomination, if my nominations are rejected in a wrong manner, I go to Court of Appeal and take a court order. The entire election get held up. Then what happens? Minister has to appoint an interim committee. That will prolong for another few months or few years until the entire case is over. Or they will appeal against that to the Supreme Court. So by bringing Sports Dispute Resolution Act, amending this section 30, that will resolve most of the problems. And also minister will have a proper frame of mind to develop the sport and support the sport, not to become the judge of the inquiries. Final determination, according to the whole act, says that the minister's final determination is the final decision. So that is wrong. During 1970s, they have implemented this section, but we have to amend that. And also, by bringing the sports dispute resolution, there will be more matters will be sorted out within the flexible and time, and also the cost effect will be much lesser, and there could be a proper mechanism, time frame, and procedures to like in the other arbitrations, and arbitrator or three or four or five arbitrators will be the final determination or order. That will be the thereafter that could be the order for the final decision. So that will not get involved with political system, and the sport has to be free and fair. It has to be everyone should get the equal opportunity. Whether it should go according to the talent, and it should go according to the rules and regulations. Otherwise, what happens is, I won't say certain unfair issues will happen. These are the problems that we are finding in most of the sports bodies. So we could be able to sort out this by bringing this new amendment and also bringing the new Dispute Resolution Act. But the reason why I want to tell you is, and also interim committees is basically international. Mr. Dharmavardhana will also knows that international sports bodies like International Olympic Committee, then International Cricket Council, FIFA, they are not agreeable for interim committees. Interim committees means interim arrangement given by the sports minister or certain sports bodies. If the sports body violates the national rules and regulations and go against the government policy and or any corruptions or any malpractices, minister could gazette that and dissolve the committee, elected body, and thereafter he could appoint the interim arrangement for a certain time period. So these are the areas that we should amend. By doing that, we should be able to validate the sports law. But there should be check and balances. Now, for example, Sri Lanka is still funding the sports. We have the sports fund. that fund is given by the Treasury. So we have over 74 sports registered under Ministry of Sports. We are only talking about cricket, football, rugby, badminton, and so on and so forth. How about the other sports? For example, Sri Lanka is the world carom champion in most of the years, or either we become runners-up. But funding is done by the ministry. So if it is a government money is spent for the sport, the ministry should have the right to find out whether this money has been spent improperly, whether they have these. So that's why I say, if you are going to decentralize and give the 100% freedom, we will go further down, because with the international bodies are always wants to have their freedom. That's the reason why India went against the Olympic Committee, and they said no, law of the country is valid. They specifically said, Supreme Court, that the Olympic Congress held at Copenhagen in 2019. It was resolved that the National Olympic Committee is required to be fully competent with the law of the land. And they couldn't ban India. They said, okay, if you want to ban, you ban. But law of the country is valid, because it is our people, our citizens, our flag, our country. We have to respect and honor their International Code of Ethics. But we have to do according to our country law. That our country law is the supreme law of the country. And similarly, in China, who is the Olympic Committee chairman? Minister of Sports. They don't get involved with China because China is very powerful. Sri Lanka in 2013, they got involved because our Olympic Committee members went against the government because they wanted more freedom and they wanted to have their own finances and do the spending according to their own way, not according to the government auditor. So all what I want to say is, if you bring this Sports Dispute Resolution Act and also do the certain changes, there will be better for the sports. There will be good for the lawyers and also for the sportsmen. And we will have more agreements, resolving disputes, and so on and so forth.
Thank you. So this question is the final question, because the time doesn't permit us to go any further. To President's Counsel, Mr. Sumati Dharmawardana, sir, you stated that the sports law is a masterpiece. My final question to you is, sir, when you look at it, sir, the national sports associations do have undemocratic practices. So is there any way that this could be addressed through the regulations, bringing in new regulations?
Yes.
Thank you, Danya. Why I said it's a masterpiece is because at that time, the drafters, in their own wisdom, had given a lot of leverage to bring in regulations to cover the developments. Because at a time when you enact a law before the parliament, it's very difficult to capture everything, because what comes within a spectrum is limited at that particular time. That was in 1973. However, there were major developments in the sporting arena. There was provision to bring in regulations. And to answer your question with regard to the undemocratic practices, at the moment, under the chairmanship of senior practitioners and the members of the sports ministry, until we bring amendments to the sports law, we are considering in bringing certain amendments to the regulations to curb and control paper clubs. I call it paper clubs in my own terminology, because you set up a club, it's only on papers, and they get very valuable voting authority, and they go and cast vote based on somebody's request. And due to that, certain people get elected to national sports associations. And certain groups control these sports associations. And I don't have to elaborate, whole country has seen the results. So we can't wait till we go before the parliament. I have brought it to the notice of the new Minister of Sports. He had principally agreed. I think Mr. Kirtinanda is also in the same committee with us. We are doing certain amendments, and already the Director General of Sports had called for observations from the National Sports Associations with regard to the proposed amendments. And we have to bring a voting structure, in my view, when it comes to the National Sports Associations elections. The certain category, we have to categorize the member clubs or the associations, the affiliated to the National Sports Associations. If not, an association or a club which has a gymnasium, which has their own grounds, and which has their own teams of A, B, C and category, get the same vote as of a paper club who doesn't have a gymnasium, who doesn't own a ground. They have not taken part in any of the tournaments, and the end result, whole country knows. I don't want to say. So I think we are on the correct track, and let's hope for some tangible results in the coming few months.
Thank you very much, gentlemen. And it was a privilege to be associated with such a distinguished panel who are experts in sports law. And I'm sure the viewers heard from the best in the industry. And we have covered the areas of the sports law, the various amendments that have been brought in on the sports law. And this has been a very comprehensive session. So if you have any questions, you can direct it to us, to the BSL, and we will forward it to the distinguished speakers who will make sure that they will get back to you on those queries. And also, finally, let me conclude by thanking the BSL for organizing this very valuable discussion on sports law and regulation. And it's a very vast subject. Finally, let me say that sports is a global language. It doesn't have a race or caste or creed, but it is something that everyone would like to get involved. And for Sri Lankan, especially Sri Lankan context, the only thing that is universal in creating happiness amongst our people is sport. So sports need to go on, and regulation of sports is very important to ensure that the best results are achieved for the sake of the country. Thank you, ladies and gentlemen.
Thank you very much. Have a good day.
Thank you very much. And I think we were able to do justice in a short span of time. I forgot to mention about Mr. Tanuja Migahavatta, who introduced us. And thank you, Mr. Danya Gunawardana and the BSL for organizing this. Have a good evening.
All the very best. Thank you very much for everyone.
Thank you, sir. Thank you all.
Thank you, sir. Thank you, Mr. Danya Gunawardana. On behalf of the BASL and the Seminars Committee, I would like to thank Mr. Chandana Liyanapatapandi, President's Council, Mr. Sumuthi Dharmawardana, President's Council, Mr. Panduka Kirtinanda, Attorney at Law, and Mr. Danya Gunawardana, Attorney at Law, for this very informative and valuable session. I would also like to thank all of you who joined us through Zoom and YouTube, and for the questions that you have submitted to make this webinar an interesting one. Thank you, everyone, and do join us next Saturday at 5 p.m. for the 54th webinar of the same series. Stay safe and good night.